aspects which I would like to highlight. Constitutionality lies the patent illegality. Now, how do I demonstrate that? So, in the first place, it has been argued extensively that the effect of Constitutional Order 272 is amendment of Article 370, Clause 3. This has been extensively argued. This has been done via the route of Article 367. Now, 371D empowers the President to apply the provisions of the Constitution to Jammu and Kashmir. Now, with such exceptions and modifications, these are the words used. Now, the question that arises is whether this power to modify, whether there are any implied limitations on this power. This is the first my submission. Now, take for example, while applying the Indian Constitution to Jammu and Kashmir, the modification says Article 21 will not apply, Article 14 will not apply. Will it or will it not trouble your conscience? So therefore, my first submission is that there are implied limitations on this power to modify. And what are those limitations? We'll examine. So what have they done? Instead of Constituent Assembly, it is replaced by Legislative Assembly. Whether this is permissible, whether it falls within the ambit of the term modification, or it goes far beyond that. So if your lordships look at the Constitutional Order 272, it adds the word in the Constitution of India as it originally stands. There is no such definition. So it's an addition. I am prepared to assume for the time being that modification can take in its within its compass even addition. But the question is that you are replacing a fundamental concept, the core concept of Constituent Assembly by another legal concept known as Legislative Assembly. The fundamental difference between these two concepts is well known. Now, therefore, your lordship will see that a Legislative Assembly is a product, is a creature of Constituent Assembly. Now, therefore, in my respectful submission, this exercise is not permissible. Now, take another example, which is to be found in the judgment of Justice Khanna in Keshavananda Bharati case. I will invite your lordship's attention. His lordship had raised the question that suppose the Parliament, in exercise of its constituent power, says that the existing Parliament will continue for 50 years. Will it or will it not be a mockery? Kindly see that paragraph in the judgment of Justice Khanna. Your lordship will get it in PDF page. Yeah, I'll just. So the PDF page is 7426.
Which volume?
This is the volume. Volume 15. The PDF page is 7426. No, sorry, I stand corrected. 527. 571.
Volume 50.
571.
Volume 15.
And the paragraph is 1423. Kindly see what the Lordship says.
It's at page?
Page 1423. Sorry, paragraph 1423. PDF page
571.
571. I get confused between PDF page and the
Paragraph
page that I have. Paragraph 1423, sir. So this is how that para runs. Apart from the fact that the best guarantee against the abuse of power of amendment of Part 3 of the Constitution, there is another aspect of the matter. Even if Part 3 may be left intact, a mockery of the entire parliamentary system can be made by amending Articles 85 and 172, which are not in Part 3, and according to which the life of the Lok Sabha and the Vidhan Sabha of the states, unless sooner dissolved, would be 5 years, and by providing that the life of existing Lok Sabha and Vidhan Sabha shall be 50 years. This would be a flagrant abuse of the power of amendment, and I refuse to believe, etc. Now, this is precisely the situation. The second judgment on which, of course, this is the only observation made in the judgment. I am not saying that this constitutes the ratio, but it is something which your Lordship will bear in mind. Now, kindly see the second judgment on which I place reliance. That is Indri Delilaw's case.
Indri
Delilaw's case, and it is there in volume 25, and the PDF page starts at page 524, and I invite your Lordship's attention to page 546. So on that page,
What's the
section
PDF?
7,
Which is the PDF number?
546.
PDF number.
So on that page, your Lordship will find section 7 has been quoted.
Para?
Could you please repeat
Para
the
41 of the judgment.
page?
546.
524 I have, 546 now.
And para 41, Lord,
Which is the volume? Sorry.
volume
25.
25. Volume 25. So kindly see where their Lordships have quoted the section. In para 41, the provincial government may, by notification in the official gazette, extend with such restrictions and modifications as it thinks fit to the province of Delhi
Section 7.
or any part thereof, any enactment which is in force in any part of the British India at the date of such notification. Now we are concerned with the word modification. Now this has been construed by, this is a 7-bench judgment, and if your Lordships come to first Chief Justice Kanial's observations on this, your Lordship will come to page 726 of the PDF. So para 354, the power to modify an act in its extension by the order of the subordinate authority has also come in considerable discussion. Originally, when the power was conferred on the subordinate authority to apply existing legislation to specified area, it was given only to apply the whole or a portion thereof. That power was further expanded by giving a power to restrict its application also. In the next stage, however, was given to modify so as to adapt the same to the local conditions. It is obvious that till this stage, the clear intention was that the delegate on whom the power was conferred was only left with the discretion to apply what was considered suitable as a whole or in part and to make adaptations which became necessary because of the local conditions. Nothing more. Only in the recent years, in some acts, power of modification is given without any words or limitations on that power. The learned Attorney General contended that the word modify, according to the Oxford Dictionary, means to limit, restrain, to assuage, to make less severe, rigorous, or decisive, to tone down. It is also given the meaning to make partial changes, to alter without radical transformation. So this is important. He therefore contended that if the donee of the power exceeded the limits of the power of modification beyond the sense that it could be exceeding the limits of the power, and to that extent the exercise of the power may be declared invalid. He claimed that no longer a power under the term modification. On the other hand, so and so words expresses the word modify has been defined as meaning vary, extend, enlarge, limit, or restrict. It has been held that the modification implies an alteration. It may narrow or enlarge the provisions of the former act. It has also been pointed out that under the powers conferred by the Delhi Laws Act, the central government has extended the application of the Bombay Debtors Relief Act to Delhi. The Bombay Act limits its application to poor agriculturalians whose agricultural income is less than so and so. Under the power of modification conferred by it, the Delhi Laws Act, the central government has removed this limit on the income, with the result that the principles, policy, and machinery to give relief to the poor peasants or agriculturists with an income of less than 500 is made applicable to Delhi to big landlords, even with an income of 20 lakhs. This shows how the word modification is understood and applied by the central government and acquiesced in
Yes,
by the
Mr.
Indian
Naphade,
nation.
we've seen that, yes.
Now, this is a classic example, and this is precisely what has happened. There is a qualitative difference, conceptual difference between the Constituent Assembly and the Legislative Assembly. So the same thing has been repeated. I'll just give to your Lordship the paragraph numbers. That is Justice Mahajan, paragraph 4014. The PDF page is 760. Justice Vivian Bose, para 316, PDF page 698. Justice Fazal Ali, para 46, PDF page 553, and Justice Mukherjee, paragraph 155, PDF page 613. So your lordships have laid down that there are implied limitations on the power to modify. And the one classic example I gave was, suppose they say no Article 21 in Jammu and Kashmir. Whether such modification can be sustained. Now this judgment was cited in Puranlal Lakhanpal. And I want to show to your Lordship what the judgment says. So kindly come to the judgment in Puranlal's case. Your Lordship will find it in volume 1, PDF page 2426. Judgment was delivered by Lordship Justice Vanchu. Fortunately, there is only one judgment, so that we understand the ratio.
Volume 1.
Yeah.
Page
Otherwise,
number?
we are grappling to find out what is the ratio of case 1 and case.
Page number?
The page is PDF page is 25. The judgment begins at page 24, and It is in volume 1. Now kindly see, my lord, Article 81 was modified. Now this is the modification. Article 81 shall apply to subject to the modification that the representatives of the state in the House of the People shall be appointed by the President on the recommendations of the legislature of the state. So instead of a direct election, the indirect election, that the legislature of the state shall recommend the names of persons who are to be appointed as members of the parliament to represent J&K. Now, this was impugned on the ground that the modification crosses the legitimate limits. Now, in paragraph 3, your lordships have said on page 25, PDF page 25, this is what the paragraph 3 says. And according to me, this is the ratio. Before we consider what the word modification means in the context of Article 371, let us see what the President has actually done in the matter of modification of Article 81. The modification prescribes that the 6 seats in the House of the People from state of Jammu and Kashmir would be filled by nomination by the President on the recommendation of the legislature of the state. Now in form, the seats will be filled by nomination by the President, but in reality, what the modification provides is indirect election in place of direct election to these seats in the House of the People. The modification lays down that the President will nominate members to these 6 seats on the recommendation of the legislature of the state. The President must therefore nominate only those who have been recommended by the legislature of the state, which is elected on adult suffrage. Now, the only way the legislature can make a recommendation for this purpose is by voting. Therefore, in effect, the modification made by the President is that the 6 seats to the House of the People from the state of Jammu and Kashmir will be filled by indirect election and not by direct election. The element of election still remains in the matter of filling those seats, though it has been made indirect. In these circumstances, it may not be possible to say that there has been a radical alteration in the article. Now, this proposition itself may be debatable, but the point is that in paragraph 3, your lordships have said that there is no radical alteration. Now, in paragraph 4, then their lordships say, but assuming that the introduction of the indirect election by this nominee is a radical alteration, and that is permissible. Now, how do I deal with this para 4? So my submission is that 2 issues arose before the court. First, whether it's a radical alteration, and second, assuming it's a radical alteration, whether it is within the ambit of 371D. Now, the second issue did arise for the court's consideration, but in my respectful submission, the determination of this issue is an arbiter and not ratio. What is the difference between a ratio and an arbiter? A ratio is that proposition which the court has to decide, has to lay down, so that the case is finally disposed of.
So according to you, once the court had held that this was not a radical modification, the question as to whether a radical modification is permissible really didn't arise. That was moved. Got it.
And for this purpose, I rely upon a judgment of the Bombay High Court. Unfortunately, it was not there in the, but we have circulated, I'm told. And I just want to show to your lordship how Chief Justice Chagla deals with this concept of ratio and arbiter.
On the second aspect, what does the court, just let's see that.
The second,
The obiter, let's see the obiter.
The paragraph 4 is an obiter according to me.
Let's read that.
Yes. All right, I'll read that. But even assuming that the introduction of the indirect election by the modification is a radical alteration.
I will return after lunch.
Lordships want me to read paragraph 4.
Just a few lines from that para and then we can move on to the next one.
Something which I want to bring to your Lordship's notice. This, if your Lordship sees the first para of the judgment, where it refers to the presidential order of 1954, in the very first para of the judgment. Now, the Article 81 was amended, was modified with the concurrence of the state government. So there was a democratic element in that. Now in this context, kindly see para 4. Some of the observations in para 4, as I said, are too wide. And if they are accepted in toto, the entire constitution of India can never be applied to Jammu and Kashmir. If taken to its logical conclusion. But even assuming that the introduction of indirect election by this modification is a radical alteration of the provisions of Article 81, the question still remains whether such a modification is justified by the word modification as used in Article 371. We are here dealing with the provision of a constitution which cannot be interpreted in any narrow or pedantic sense. So I pause here for a minute. Their lordships are now comparing Delhi law's case and this provision in the constitution. Now my humble submission is that as far as Delhi laws is concerned, is ordinary statute. Therefore, there can be a more flexibility.
Yes.
But when you are dealing with a constitutional document, the limitations should be on a higher scale. This point is missed out. Kindly see further. The question that came for consideration in the Delhi law's case was with respect to the power delegation.
Yes, Mr. Naphade, I think we've got your point that, you have to have some implied limitations and therefore these observations in para 4 are of a very broad amplitude.
Your Lordship sees the para 4.
We'll have to hear the other side. You made your point. We'll hear the other side on this.
Completely wipe out.
All right. What is the next point, Mr. Naphade?
So my next point is, which I will indicate at the end, because I have to deal with Article 3 and 4 as briefly as possible. But my next point is, what happens to the Constitution of Jammu and Kashmir? That's a thorny question. So if I recapitulate the facts which have been extensively set out in Premnath Kaul's case and which has been cited before your Lordship.
So what is the submission on this aspect?
The submission which I want to make is this. So it traces out, the judgment traces out how the sovereignty came to be vested in the Yuvraj. Right from 1925 to 1951 or 49. And thereafter, two important developments. Yuvraj accepts the Constitution of India. But that is in the light of Clause 8 of the Treaty of Accession. Clause 8 recognizes that barring a few items, the sovereignty of the Maharaja remains. Now this sovereignty, which is recognized by the accession treaty, where and when does it evaporate? That's the question. Because as a result of this constitutional order and the Reorganization Act, the result is the Jammu and Kashmir Constitution comes to an end. Now let me elaborate this point, sir.
But that's postulated, and over the passage of time, period of time, what was left, as pointed out by Dr. Navan, was only limited, very, very limited. Small.
Several provisions came to be applied, no difficulty. But the core of the J&K constitution has remained intact till date, which I will indicate to your lordship. So therefore your lordship will see that it is in 1951 that Yuvraj convened the Constituent Assembly to frame the constitution. What is the authority by which he could do so? His authority to convene a Constituent Assembly has not been questioned anywhere. So therefore, J&K Constitution is a constitutional document. That's the only conclusion possible. Now my submission is going to be that no matter how widely you interpret the power under 371D, the core of the J&K Constitution must remain. And what is that core? So kindly come to J&K Constitution. That is in volume 2. So in the first place, the state.
So can you itemize the core? I mean, can you just sort of summarize what would be the core?
The core I am indicating, that is part 5 and part 6 of the J&K Constitution.
That is the executive.
That is part 5 is executive and part 6 is the legislature.
Additional document volume 2. Additional document.
Sir, when the constitution was ushered in,
which is one more provision? Part 5 is the
executive, governor, council of
Part 6 is the legislature, and what else?
And the legislature.
These two.
And kindly see,
you said one more.
Section 3 and 4. Sections 3.
Document volume.
And 5. That is part 2.
Yes.
Now the state of Jammu and Kashmir has its origin also in this, its continuation. It originally existed. There is a long history which has been set out in Ramana Kaul's case, right up to Independence 1947 Act, Treaty of Accession, etc. Now kindly see the territory, section 4. Constitution. The territory, the PDF page 18. The territory of the state shall comprise all territories which on the 15th day of August 1947 were under the sovereignty and sovereignty of the ruler of the state. Now this is the territorial integrity of the state. Now there is no provision in the Constitution of India by which the J&K Constitution can be abrogated. There is no express provision. The only question is whether through the route of 371D this can be achieved. Now this depends upon the question, because Article 370 itself recognizes the Constituent Assembly. And the concept of Constituent Assembly is that it's a sovereign body. Now there can be a constitution within a constitution. That is something which your lordships have recognized. I'll just indicate to your lordship. That your lordship will find in the judgment of Keshavananda Bharati. Para 2072. I just indicate PDF page 79091.
Volume?
Volume 15, sir.
We'll look at it. Page, just give us the page 70.
790.
Which says that there can be a constitution within a constitution. All right.
That's what
Whose judgment is that?
Justice Chandrachud. Now, therefore, your lordship see the existence of portion.
It should like that.
Yes.
Thus, the true ground of division by virtue of which the nature of the constitution is whether it is flexible or rigid, that depends upon whether the process of constitutional lawmaking is or is not identical with the process of ordinary lawmaking. A typical instance of flexible constitution is that of the United Kingdom. The constitution of the former kingdom of Italy was also flexible, so flexible indeed that Mussolini was able to profoundly violate the spirit of the constitution without having to denounce it. The constitution of the United States is rigid as it cannot be amended without the special machinery being set in motion for this purpose. In short, we may say that the constitution which cannot be bent without being broken is a rigid constitution. The Indian constitution, considered as a whole, is a controlled or a rigid constitution because broadly none of the articles of the constitution can be amended otherwise than by special procedure prescribed by Article 368. Certain provisions, therefore, like Article 4, read with Articles 2 and 3, Article 169, Para 7 of the 5th Schedule, and Para 21 of the 6th Schedule confer power to amend the provisions of the Constitution by ordinary lawmaking process. But these amendments are expressly accepted by the respective provisions from the purview of Article 368. Schedules 5 and 6 of the Constitution are in fact constitution within a constitution. So therefore, the existence of J&K Constitution is recognized by the Constitution of India. How do I show that? Kindly turn to Article 370.
That you need not labor because according to you, the Constituent Assembly itself.
Now the question therefore is that if the Jammu and Kashmir Constituent Assembly was convened by a sovereign authority, that sovereignty merges into the sovereignty of the Constituent Assembly and it ultimately gets transferred to the Constitution of Jammu and Kashmir. Now, therefore, you have two sets of documents. Article 371D, if it is deployed in such a manner that it results in the complete abrogation of J&K Constitution, is something which is, in my respectful submission, not contemplated.
All right. What is the next point, Mr. Naphade?
So my next point is, now, originally there were two routes. One was 373 itself. After 1957, that route is closed.
Yes.
Then we take recourse to Article 368. So in para 7 of the judgment in Sampat Prakash, para 7 in Sampat Prakash,
Yes.
it was relied upon by Mr. Dave. I don't wish to therefore repeat that.
Para 7 of Sampat Prakash.
Sampat Prakash.
What is the submission on that?
Justice Dave, Mr. Dave said that your lordships in this judgment have recognized that Article 373 is still in force. This is much after 1957. Now that route is obviously closed. But Sampat Prakash goes a step forward and says that even with reference to 368, you can't do it. Para 13. Para 13 of Sampat Prakash, I'll show to your lordship that your lordship will get PDF, Volume 1, PDF 3033. Now, this, in my respectful submission, is no longer good law. In view of what the 11 judgments in Keshavananda Bharati say. Every judgment in Keshavananda Bharati says that every part of the constitution can be amended. Of course, some judgments take a view subject to the rider that basic structure can't be touched. But there is not a single judgment in Keshavananda Bharati which calls out an exception. And therefore, in my respectful submission, the only route which was constitutionally permissible is through 68.
That's what Mr. Dave also argued.
Yes, that's what. So therefore, to that extent, para 13 of Sampat Prakash is not a good law. But para 7 remains. So therefore the question of what do we do with J&K Constitution? The core provisions, as I said, part 5 and part 6. The executive and the legislature of J&K are created by J&K Constitution. Now, by reference to Articles 3 and 4, by taking recourse to Article 3 and 4, these constitutional provisions contained in J&K cannot be done away with. So, two submissions in this regard. The framers of the Constitution were aware of the fact that the Constituent Assembly for J&K is in the offing. Clearly reflected in Article 370. Now, therefore, the question is that does it not contemplate when it says that provisions, this Article 370 special status, provisions of the Indian Constitution can't be applied unless you follow a certain procedure, does it not contemplate clearly that the Constitution of India, as framed by the Constituent Assembly, recognizes the existence of J&K Constitution? And therefore, doing away with that can only be through a constitutional process. Now, therefore, your Lordship will see that this is a limitation. The existence of J&K Constitution is a limitation both on the power of the President under Article 371D, also the Parliament's power under Articles 3 and 4. So Part 6 of the Indian Constitution has never been applied to Jammu and Kashmir, except a few provisions here and there. But the core, the executive and the legislature, those provisions contained in the Indian Constitution have never been applied to J&K. In the judgment in NCT of Delhi versus Union of So this is the four characteristics which your lordships have read. In paragraphs 292, 290, 291, 292, 296, 298 and 305. So kindly see what your lordships have said. The framers of the Constitution were aware of the challenges which the new instituted democracy could face. In his address to the Constituent Assembly, but kindly come, my lord, to the straightaway to 305. This is the discussion which I don't wish to trouble you. PDF page 160. There are four abiding principles which are essential to the understanding the content of the Constitution. The first is that as a political document, the Constitution is an expression of the sovereignty of the people. This is satisfied by J&K Constitution because the Constituent Assembly was convened by the Maharaja, Yuvraj, because of clause 8 of the accession. The second is that the Constitution seeks to achieve its vision of a political and social ordering on the basis of democracy. A democratic form of government recognizes that the sovereignty resides within the people. Popular sovereignty can exist when democracy is meaningful. This is also satisfied. The third principle is that the Constitution adopts a republican form of government in which the powers of sovereignty are vested in the people and are exercised directly or through their elected representatives. This is also satisfied. The fourth, which is not the least in importance, in the secular ideology of the Constitution, for it is on the foundation of secular order that freedom, liberty, and dignity and equality to every citizen achieve. Now, if these are the four characteristics of a constitution, then in my respectful submission, J&K Constitution satisfies that. Now, when we talk of sovereignty, it does not necessarily contemplate external sovereignty. I accept that the concept of sovereignty vis-a-vis J&K is not external sovereignty. Because defense, foreign affairs, etc., the subjects were already accepted in the accession treaty. I am not therefore suggesting for a moment that this sovereignty is absolute in the sense in which that concept is understood in international law. I wonder whether, given the current scenario under the international law, is there anything called absolute sovereignty? Because there are so many conventions by which the state bind themselves. And your lordships have recognized that your lordships courts can enforce the international conventions, though India may not have ratified that. So therefore, the absolute sovereignty concept, which was some 200 years ago, is no longer exists even in international. But the fact remains that that concept of sovereignty has some content. And that content with regard to Jammu and Kashmir is that their internal affairs be conducted at least in accordance with Part 5 and Part 6 of the J&K Constitution. A 371D can make only marginal inroads. Anything beyond that, which results in the constitution of J&K evaporating, it can never have been contemplated. Now, in the alternative, even if we accept the concept of internal sovereignty, with respect to other states, keep aside Jammu Kashmir, because people get obsessed with the concept of special status. Forget the special status also for the time being. But your lordships in Bomai have quoted with approval a passage from Sirwai's book, which talks of internal sovereignty. Your lordship may have a look at that para. That is para 97. It is PDF
Volume
volume 2,
page.
page 113. Para 97, sir. Where Sirwa has been extensively quoted. Therefore, every state in this country has internal sovereignty.
Para?
Para 97. PDF page 113. Where Sirwa has been quoted extensively. I don't wish to read that entire portion. But kindly see B clause, the subpara B on page, PDF page, next page, your lordship, 114. The Parliament's power to alter the boundaries of states without their consent is a breach of federal principle. And subpara D, external sovereignty is not relevant to the federal nature of a constitution, for such sovereignty must belong to the country as a whole. But the division of internal sovereignty by a distribution of legislative powers is an essential feature of federalism, and our constitution possesses that feature. Now, if this is so with regard to the other states, much greater weight must be applied to J&K constitution.
Yes, Mr.
So in Santosh Gupta's case, 2017 2 session, which your Lordship will find in volume 1, PDF page 136.
What are you citing it for?
This is because this judgment says that J&K sovereignty has come to an end. Probably the Union of India wants to rely upon that. That is how it has come in the. So I wish to point out to your Lordship that what was the issue in this matter? The issue was whether the provisions of the SURFACE Act applied to J&K or not. There was a constitutional challenge, which was upheld by the High Court. And the High Court referred to in the judgment several times the sovereignty of the J&K. And also said that this does not fall within the list 1. Now this judgment takes a view, if your Lordships look at paragraph 43 and 44 at PDF pages 133, that SURFACE Act falls principally within the provisions of, within the ambit of entry 45 and entry 95, list 1. That's the finding in paras 43 and 44. Now, having come to this conclusion, that since it falls in entry 45 and 95, the list 1, the question whether J&K constitution had sovereignty or not does not survive for consideration. Therefore, this is an arbiter applying the test which Chief Justice Chagla applied in that Bombay judgment, which incidentally I forgot to refer. It is there in volume 29.
We look at it, yes.
I just read out. So page 5 of that. This is what his Lordship. But the question still remains as to what is an arbiter dictum given expression to by the Supreme Court, which is binding upon the courts in India. An arbiter dictum is an expression of opinion on a point which is not necessary for the decision of a case. This very definition draws a clear distinction between a point which is necessary for the determination of a case and a point which is not necessary for the determination of the case. But in both cases, points must arise for the determination of the court. Two questions may arise before the court for determination. The court may determine both, although only one of them may be necessary for the ultimate decision of the case. The question which was not necessary for the determination of the case would be ratio decision. The opinion of the tribunal on the question which was not necessary to decide would be only an arbiter. But I don't think that this view can be found fault with. So therefore, in para 47 in Santosh Gupta's case, his Lordship says that sovereignty has come to an end. In the first place, this is clearly contrary to in Premnath Kaul's case, which has been cited by Mr. Dhawan. I just want to show to your Lordship only one observation from Premnath Kaul's case that your Lordship will find. That is para 16 of that judgment. What is the PDF page? Well, second line from the top, we have no doubt that the Yuvraj was perfectly competent to issue the proclamation of 20th April 1951, under which the Constituent Assembly ultimately came to be elected and convened. If the Constituent Assembly was properly constituted and it decided not to pay any compensation to the landlords, it is difficult to understand how the validity of these decisions can effectively be challenged. Your Lordships have specifically recognized the power to convene a Constituent Assembly. That's an act of sovereignty. So there is one more para. He has read para 42. Who has read? Yeah. I'm sorry, I read para 42, not para 16. I stand corrected. So therefore, in my respectful submission, the observations in para 47 in Santosh Gupta's case to the effect that the sovereignty has come to an end is clearly contrary to Ramana Kaur's case. In any case, it's an arbiter. In any case, there is not much of discussion in that judgment on this issue. And it's a judgment of only bench of 2 learned judges. So my next point is Article 356. Much has been said by Mr. Dave and others, but there is one aspect which I want to bring to your highlight. It may be an overlap, but there is particular aspect which I want to emphasize. What is the effect of the presidential proclamation? So kindly turn to Article 355. What is the purpose of 346 or 356? There is breakdown of the machinery, accepted. The affairs of the state cannot be carried on in accordance with the Constitution, accepted. But does that justify doing something which is unconstitutional? So in the first place, the J&K Assembly was dissolved in November 2018 and the governor assumed the powers. He assumed the powers under the J&K Constitution. And not the 356 proclamation came in December 2018. This presidential proclamation under 356 is clearly without jurisdiction. Clearly without jurisdiction. The reason is that the governor has already dissolved the assembly. The governor has assumed all the powers of the state. Now, certainly the governor assuming the powers can't be a breakdown of the state machinery. It would be absurd to suggest that, and therefore President has to intervene under 356. It's a jurisdictional issue. And 356 has been invoked for a collateral purpose. And that collateral purpose is apparent on the face of the record. You suspend the 2 provisos to Article 3. The first proviso which applies to all the states that you can't alter the boundaries, change the name of the state, etc., without first giving an opportunity to the state concerned to express its views through its legislative assembly. You suspend that. Second proviso, which applies to J&K without the consent of the legislative assembly of J&K. Now, I cannot understand if there is breakdown of the machinery, what is the necessity, what is the rational nexus to suspending these provisos? There is an implied limitation on this power. Can you suspend the entire constitution? Because the president has issued proclamation under 356. Once you accept that there are implied limitations, the suspension of any part of the constitution as a result of presidential proclamation under 356 must have a rational nexus to the objective that is to be achieved. And the objective that is to be achieved is Article 355. Kindly see Article 355. The duty of the center. It shall be the duty of the Union to protect every state against external aggression and internal disturbance, and to ensure that the government of every state is carried on in accordance with the provisions of this Constitution. Now read Article 355, 356, 357 conjointly. And the only result is that the state as an constitutional entity must survive. Now, what is the purpose of suspending the proviso? Ultimate design is abolishing the state of J&K. Contrary to the mandate of 355. Therefore, your Lordship will see the J&K Reorganization Act is born, is conceived in an unconstitutionality. Patent. Now let me test even the wording. I have shown to your Lordship the context, but kindly see what 357 says. Sorry, 356C. Make such incidental and consequential provisions as appear to the President necessary or desirable in giving effect to the objects of the proclamation. Now, suspension of those provisos, what is the nexus? In the entire affidavit of the Union, I don't find any light being thrown on this aspect of the matter. Then kindly see 357. (357)(1)(b). For Parliament or for the President or other authority in whom such power to make laws is vested under subclause A, to make laws conferring powers and imposing duties or authorizing the conferring of powers and the imposition of duties upon the Union or officers and authorities thereof. Now this is a power to make law. The way Dr. Dhawan, everybody has argued that 356 is a temporary thing.
भाई को पूछो कि क्या
is this, that the power or the function that the state assembly performs under the provisos to Article 3 are not power of making law. Article 357, 356, they refer to the state legislature's power to make law, which is taken over by the parliament or by president by issuance of ordinance. But this is not that power. The power under proviso is not law-making power at all. And this is recognized by judgment in Keshwananda Bharati's case. Again, I have to refer to Justice Khanna's just observation. And that is para 1351, which volume 15, PDF 542. So this is with reference to proviso to Article 368. But the logic would equally apply to proviso to 3, Article 3, my submission.
And your argument is that 357(1)(a) provides for Parliament to confer on the President the power of the legislature of the state to make laws.
Make laws.
And that function which you discharge under the proviso to Article 3 is not the power to make laws. We got it.
Not law-making power.
We made the point.
Yeah.
What's the next?
So therefore, it can't get the President can't take over that power.
Just give us the
1351.
Volume.
1351. Articles 248 read with entry 97 list 1 contemplates legislative process. If the amendment of the Constitution were such a legislative process, the provisions regarding ratification by the legislature of states.
What is the PDF page? PDF page?
542.
Yes.
Article 248 read with entry 97 list 1 contemplates legislative process. If the amendment of the Constitution were such a legislative process, the provisions regarding ratification by the legislature of not less than one half of the states in respect of certain amendment, the Constitution would be meaningless because there is no question of ratification of a legislation made by the Parliament in exercise of the powers conferred by Article 248 read with entry 97 list 1. It is noteworthy that the ratification is by means of a resolution by the state legislature. The passing of a resolution can plainly be not considered to be a legislative process for making a law. The state government also do not come into the picture for the purpose of ratification, etc. So therefore, your lordship says that everything that the legislature does is not necessarily law-making process. So therefore, the powers under the proviso would have never been taken. So therefore, Article 356 proclamation suspending those two provisos which have no nexus whatsoever to the object to be achieved under 356 clearly collateral. So now I come to interpretation of Article 3 and 4. So the reference I made to Article 355, but some passage from Bomai I must show to your lordship. Para PDF page 155
Of?
of volume 2. Now kindly see what that para says. This is with reference to Article 355 on which I place reliance. That the purpose of 356 is to restore the state. Para 160. The crux of the question.
Just 1 second. Which page are you reading? 155.
The PDF page 155.
Which judgment is this?
Bomai.
Volume 2. Para 168.
Para
160.
160. I think judgment of K. Ramaswamy. The crux of the question is width of the President's power under Article 356. This has a direct bearing. It finds its birth from a family of emergency provisions in Part 18 of the Constitution. Article 355 imposes duty on the Union to protect states against external aggression and internal disturbance and to ensure that the government of every state is carried on in accordance with the provisions of the Constitution. As a corollary, when the government of the state is not being carried out in accordance with the provisions of the Constitution, a constitutional duty and responsibility is put on the Union to set it right. So therefore, if the machinery has broken down, to set it right means to see that the state normalcy is restored. So therefore, Article 356 cannot be read in isolation. The purpose of 356 is to restore under Article 355. That's the purpose for which. Now, another reason to say the same thing is said by Justice Jeevan Reddy and paragraph 272 and Justice Sawant at para 56-57. I did not read those paras, I'm just giving to your lordship those parameters. So the sum and substance of BOMA is this, that restore the state to normalcy because that's a duty cast upon you under Article 355. Now there is one more reason to say that the exercise of power under 356 is for a collateral purpose. Because ultimately what they want to achieve, get away with, do away with Jammu and Kashmir state. That point I already made. I have also said no jurisdiction because the governor had already assumed the powers after the assembly was dissolved. There is one more reason which is to be found in judgment of this court in K.N. Rajgopal versus Karunanidhi. 1972, volume 4 SCC, page 733. PDF page 68-69.
Of which volume?
So PDF page 68-69, volume 19. It's a one-page judgment, but has seminal contents.
Volume
19.
Paragraph, there is only one-page judgment. It is volume 19, PDF page 68-69. So this is what your lordships have said. We have just delivered a judgment in so and so. A similar question arises in this appeal, but with respect to the Chief Minister and the Minister of the State of Tamil Nadu, the relevant articles are worded similarly. The only difference is that the governor is not elected, but is appointed by the President under Article 155 of the Constitution and under Article 356 of the Constitution, makes a provision in case of failure of constitutional measure in the state. But when an assembly is dissolved, there is no failure of the constitutional machinery within Article 356, Article 164, which provides that the Council of Ministers shall be collectively responsible to the Legislative Assembly of the state, has to be read in Article 75.3, following our reasoning in that appeal, this appeal was. In other words, what your lordships have said is that once the assembly is dissolved, there is no question of machinery having failed, and therefore, consequently, there can't be a 356 exercise. So, in this context, I invite your lordship's attention to judgment in Gujarat Assembly case. Now, if your lordships have a look at Article 356, there is no provision which says that what is the upper limit. How long you can do away without an elected government. This question came up before your lordship in Gujarat Assembly case. And your lordships have said 6 months. I'll just say that judgment is in volume 19, PDF page.
Page? Volume 19 page?
Does it?
Page, volume 19 page?
I'm just seeing, page 283. Which is the panel?
Volume 18, page 283.
So kindly come to para 79 on PDF page. The PDF page. 283, sir.
283.
Para 79. However, we are of the view that the employment of the words "an expiration" occurring in section 14 and 15 of the Representation of the People Act respectively show that the Election Commission is required to take steps for holding elections immediately on expiration of the term of the Assembly or its dissolution, although no period has been provided for. Yet, there is another indication in section 14 and 15 of the Representation of the People Act that the election process can be set in motion by issuing of notification prior to the expiry of 6 months of the normal term of the House of the People or the Legislative Assembly. Clause 1 of Article 172 provides that while promulgation of emergencies is the operation, Parliament may by law extend the duration of the Legislative Assembly not exceeding 1 year at a time, and this period shall not in any case extend beyond a period of 6 months after the promulgation has ceased to operate. Further, under Article 123(2)(1)(3) of the life of an ordinance promulgated either by the President or by the Governor, as the case may be, is 6 months, and repeated promulgation of ordinance after 6 months has been welcomed by this court. Again, under Article 109, 110, and 111, and analogous articles for the State Assembly, money bill has to be passed by the House of the People or by the Legislature. So the period of 6 months has been read by your lordships. Then there is one more para of in the same judgment. This was of Justice Khare, and there is para 147 in the judgment of Justice Prasad. PDF page 316. So this is the ratio. Para 147. Almost his lordship has echoed what Justice Khare has written in the 79, which I read out. Now I come to Article 3 and 4. Now kindly see the marginal heading. formation of new states and alteration of areas, boundaries or names of the existing states. This is a clue. Of course, there is a debate whether marginal headings can be seen or not. But fortunately for us, this issue is no longer res in figura, as a constitution bench judgment of this court in Bengal immunity versus state of Bihar 1955 2 SCR, page 603 or AIR 1955.
What will be the PDF page and volume?
PDF volume 13 and page is PDF page is 144, and I take straight away your lordship to para 25.
It can indicate the general drift of the provision, but it cannot be used to supplant the actual statute.
That's correct.
The actual words of the provision.
I'm not saying. If there is some ambiguity, and there is in my respectful submission, according to me, there is not even ambiguity, there is a conscious omission in Article 3 as regards power to abolish a state. Conscious omission. So why do I say there is a conscious omission? Not only from the marginal heading, but also look at the text. Form a new state by separation of territory from any state or by uniting two or more states or parts of the state or by uniting the territory to a part of a new state. Minute details, what that power is. Then it further says, increase the area of any state, diminish the area of any state, alter the boundaries of any state, alter the name of any state. Details are given. What is the extent of that power? There is no ambiguity at all. There is not even a whisper about abolishing a state. And this has to be seen in the light of Article 1. India, that is Bharat, shall be a union of states. Two also. The Parliament may by law admit into union or establish new states on such terms and conditions as it thinks fit. So Article 1, India, that is Bharat, is the union of states. Article 2, admission of new states. Article 3 gives details of the power that the Parliament has. Now, therefore, there is a conscious omission to abolish a state. My second point.
What happens when you unite two states?
But the point is this, your lordship will see that a territory, what is the idea behind the state? That people in a given territory should have a state government. two-tier democracy at the state level, and that is how the constitutional scheme is. Some powers are given to the state, these two. They have their own government. So this concept of a state is inbuilt in a democratic structure that this constitution has built. In other words, the existence of states is a part of the basic structure. And J&K can't be an exception to it. Then why not tomorrow abolish Bengal? By what parameter? That according to me, there is a conscious omission. So Article 1, 2, 3 have to be read together. Now, there is one more reason. This alteration of boundaries, changing the name of the state, uniting two states, one state being divided into number of states, this does not amount to an amendment of the Constitution. True. So all the more reason why this power must be narrowly construed. According to me, no two interpretations are possible. There is a conscious omission to abolish a state because India is the union of states. I link it with 355 and 356. Article 3 has to be read with 355. If there is breakdown of machinery, restore the normalcy. But you can't abolish a state. And since it does not amount to a constitutional amendment, it must be strictly, narrowly construed. And this interpretation, in my respectful submission, would advance the concept of democracy and concept of federalism. Open the Article 18. Article 18. Of my argument. Now forget everything. What is the impact on the constitutional structure where everything has been turned upside down? First, what is the impact? Ladakh, under the reorganization, has no representative in the Rajya Sabha. People of Ladakh therefore do not count as far as Rajya Sabha is concerned. So much for the democracy. Now look at Lok Sabha. All existing Rajya Sabha. All existing 4 seats in Rajya Sabha go to J&K. Ladakh is left out. Consequently, people of Ladakh have nothing to do with working of Rajya Sabha, including the election of the deputy chairman under Article 89 and 90. Second, look at Lok Sabha. Under Article 81C, all union territories in the country can maximum have 20 seats. In that, you have the J&K. But look at the discrimination. Under Article 81, Clause 2, as far as other states are concerned, the number of seats that they have depends upon their population. And the Constitution further mandates that this ratio between the population and the seats for all the states shall be same as far as practicable. So in state of Jammu and Kashmir, irrespective of its population, it has no proportionate representation in the Lok Sabha. Discrimination. Article 14. Now, if you create some more union territories, that limit of 20 will have to be crossed. Today it is 19, including the 5. That's all right. But look, if working out seats for other states is a different formula. How can this be done? Other disastrous consequences. Look at the election of the president. Come to Article 54 and 55. For electing the president, the electorate consists of members of parliament, both Rajya Sabha, Lok Sabha, and also the legislative members of respective states. Now, J&K is not a state. Therefore, there is no MLA for the purpose of president's election. Now, to the exclusion of such a big area, no say in the election of the president, if not by direct, at least by an indirect method. But I must hasten to add that the Reorganization Act says that J&K will have the same rights as Pondicherry. And Pondicherry under Article 54 and 53 there, but this will require a constitutional amendment. You can't do it by law like this. Other disastrous consequences, Article 279A, representation in the GST Council. People of Jammu, Kashmir, Ladakh have no say as far as that council is concerned. Appointment of High Court judges. As far as other states are concerned, the governor is one of the persons to be consulted, and governor means aid and advice. So that also goes away. There are several such provisions in the Constitution which are impacted. Therefore, by a very small act which apparently looks constitutional, that is Constitutional Order 272, the whole constitutional structure is demolished, substantially restructured with J&K. I am grateful that
Thank you, Mr.
I exceeded my time.
No, Mr. Thank you very much.